John, again, I read this decision, and you're referring to an essential service. That's not what it says. I'm a little confused with what you're trying to argue about. And the last thing is, it was finally remanded back to the township to apply their UDO, which is, I think, is what you want to go argue about on an appeal. I don't understand what the concern is to come back to the zoning commission and have them review the application. What are we arguing about?
Let me walk backwards here. Hold on.
I mean, I have it marked. It's page condition 12 or 15, I believe.
Like if you look at page 34, typically what happens, and the court actually cites, and I've read this before, but I'll read it again. This matter must be remanded to the zoning hearing board with the direction that such special exception applied for be granted upon such terms and conditions as the board may deem appropriate, subsequent to whatever further proceedings may be necessary. Typically, in the case law provides the conditions have to come from the evidentiary hearing. So,
but that's not what it says. It says to come back to Cecil Township. It doesn't say anything about any evidentiary hearings.
And that's the first.
But okay, let me address that though, because your comment was that there's no procedures, or Mark West walked in with no specifications that they had to meet. It was by DEP and the EPA and Cecil Township zoning ordinance. I don't understand what your contention is.
Well, what I just read to you was another case that was cited within that case. And that's typically what happens. They send it back down and have the zoning hearing board look at it. If you look at the court's order, the court says, should the board determine within this 45-day period and within the confines of the Unified Development Ordinance objective standards and criteria, then any terms or conditions are needed to attach to the special exception application in order to ensure compliance with the UDO, it shall specify the applicable UDO provision and explain why the term or condition is necessary. And that's a little bit different, because we have to be consistent with the ordinance when we apply conditions, but the conditions come from the evidentiary record. And
how do you get that into the zoning board?
How do you get it?
It has to be taken from the zoning ordinance. So that's the only thing they can use to approve the UDO. So you're assuming that there's going to be things brought into or excluded, or in your discussion, that isn't going to happen. That was not agreed to.
Yeah, let me read you what the law is. It says, if the zoning hearing board chooses to approve the special exception application, it may attach such reasonable conditions and safeguards, in addition to those expressed in the ordinance, as it may deem necessary to implement the purpose of the act in the zoning ordinance. That's the law. The court seems to suggest that the first part is okay, that you can put reasonable conditions that are part of the ordinance, but not in addition to those expressed in the ordinance. Not in addition to those expressed in the ordinance. I don't know if you know, pick up the subtlety there, but...
Absolutely not.
Okay. Well,
okay, because again, it has to go in front of the zoning board, in front of their ordinances, in front of what Cecil is using to comply with the I-1 zoning.
Well, we have 38 proposed conditions to the ZHB, and I'm not sure the ZHB can entertain.
What does that mean, proposed?
Well, that when we initially asked the zoning hearing board to deny the application, we said in the event that you don't and you approve it, we would like these 38 conditions imposed on there, including hydrogeologic studies, air modeling, air studies.
And that's exactly what the court did not confer with.
Well, it wasn't before the court. The zoning board never got there because they denied the application. Had they approved it, then they would have looked at conditions. So now the court's ordering them to approve.
So they made a mistake?
No, they did what was right.
And they lost.
They lost, so now it comes back, as the other court said, Mike, the board should be having to look at conditions. And
okay, let's talk about the conditions then. Okay, I believe you, John. I'm saying there are conditions. What conditions are missing that they weren't going to comply with? Well, why don't we address that at the next UDO?
Well, that's what I wanted to do, and I said I don't think the court is allowing the board, based on its order, to do what it's required by law.
In this order right here, it said that?
Yeah, that's
what page?
At the end, what I just read to you, when it speaks about on page 35, it's that you have to approve within the confines of the Uniform Development Objectives, or UDO's objective standards and criteria. we have ordinance standards, and then we have conditions that the board basically can say, we want you to do this. There's nothing in the
Okay. That's exactly the answer I want. Isn't that determined through the special exception application? And that's where you're going to apply those decisions, and which were when they took their decision and made their decision. So my question is, let's go one step further. If you go to appeal this, are you not going to appeal the same thing that was in front of the zoning board when they denied the application? So why don't we just go back to the zoning board and make it work so it complies with the safety and every other issue that everyone has here?
I'm not sure the court, my problem is, I said, Mike, I'm not sure the court has given us the ability to do that.
Oh, help me out. Is that possible? Somebody say something. I mean, I don't understand. Everything can't go to the court every time somebody has an issue. That's what you have a zoning board for. I don't understand. You're talking about issues that are never going to be in front of the zoning board. Because the evidence...
Back in the day, Mike, let me try this first. Back in the day when the zoning hearing board heard the application, if they would have voted to approve the application, they then would have had the ability to put conditions on that approval. Because they denied the application...
That was exactly what I said.
Right, because that's why...
Exactly what I argued. That was the reason that I...
And why can't they do the same thing now?
That was the reason that I stood
Because they
in
lost
opposition.
in court, in the Commonwealth Court.
I know, but the Commonwealth Court said fine.
Well, now you are at the mercy of Range or Northwest because...
That's not true.
Well,
that shouldn't be true. That's the point.
No, they lost all that. Yeah.
We agree to disagree.
Well, that's why I think it should go back to the zoning people, and you should get whatever contentions you need addressed in the zoning. I mean, you should go back to the courts.
Okay, thank you, Mike, I appreciate that.
Rodowski, I live at 256 Klinger Road. I won't take long, I assure you. I've lived in this township for over 30 years. I moved here because it's a beautiful place. I still love it. I love coming home to my quiet house, away from the city, away from the traffic. But I want to tell you, at the rate we're going, I will not live to see the day that the compression station is approved or that gas and oil is seriously brought into this township. We could see some new revenue and stop the building, stop cutting down the trees, stop creating an atmosphere that is the very reason why many of us have lived here and paid taxes for so many years. I will probably die at the hand of a vehicle driving down my street, coming out of the reserve at South Point, coming from the other end of Klinger Road, coming from South Point, some BMW, some SUV, just because I want to get my mail. So the next time many of you want to approve a new housing development, you might want to consider a different form of revenue. You might consider that those of us who are potential profiteers, like Elizabeth, who has worked her whole life to claim that title, good for you. Yes, yes. You deserve it, and no one should ever take that away from you. But I don't want to die at the stake of a driver at the top of my driveway. Let's move forward. Let's be progressive. Let's do it before another township does it, and let's preserve what we have come to love in this township. Thank you very much.
117 Woodhaven Drive. I'm also part of the Timber Run plan. We've heard a lot from both sides of the argument tonight, and rightfully so. But based on just that portion of that alone, is a good reason to take this to the appeals court. Let the courts decide. This really shouldn't be up to...
They already decided.
One set of courts did one way, one set of courts decided the other way.
Thank you. Address the board. Keep the comments to the board. Thanks.
Right, but isn't that the case?
Yes, they have. We won in Common Pleas Court.
Right,
and then it went to Commonwealth Court, and
Northwest one,
it was
right?
reversed.
So,
But there's still other appellate courts available.
right, exactly. So based on that alone, I say we should appeal it and then push it forward. You know, there's both sides of the argument, and I see valid reasons for both of them. But the thing is as your due diligence as supervisors is to take it to the fullest extent of the law, make sure that everything's correct, and make sure that things are done in the right particular manner. And that's the case in this instance. So that's all I want to say, and pretty short and sweet. Thanks.
Thank you.